Good afternoon, everyone, and welcome to this afternoon's webinar. I will be speaking to you about managing limitation periods and applications to proceed out of time in family law property settlement proceedings. For those of you who don't know me, I am a family lawyer based in Sydney. I'm one of the directors of Blanchfield Nicholls, which has been recognised in the Doors Guide as one of the leading family law firms in Sydney and in Australia from 2015 to 2024 inclusive. And I have practiced in family law for just over 15 years now. So let's get started. And like Lisa said, I will be taking questions at the end, but feel free to pop them into the Q&A box, and then I will get to them at the end of the presentation. So the format of the webinar today will be as follows. First of all, I will go through the legislation. So I'll go through the Family Law Act and the requirements which are set out there. Then we will look at the case law and for some of the technical parts of these applications. And thereafter, I will take you through about 6 or 7 different cases so that we can look at how the legislation has been applied to the case law, including some very recent decisions from the Federal Circuit and Family Court. So I'm assuming most of you practiced in family law, so you would all be familiar that the Family Law Act sets out some time limits for initiation of property settlement and spouse maintenance proceedings. The statutory requirement for property applications and spouse maintenance applications for married couples is outlined in section 44 subsection 3 of the Act, which provides that a party to a marriage may apply for orders for property settlement or maintenance within 12 months from the date of the divorce. So it is 12 months from the date that the divorce order takes effect. In cases where a decree of nullity of marriage has been made, the applicant has 12 months from the date of the making of the decree to initiate proceedings for property settlement and spouse maintenance. Proceedings may be instituted outside of these timeframes, either by consent or with leave of the court. It is very important to note that no limitation period applies if the parties were divorced overseas. The full court authority in Anderson and McIntosh held and confirmed that section 44 subsection 3 had no application to foreign divorces. So very important to take instructions from clients as to where they got divorced. Now, what happens if there is a financial agreement and the agreement has been set aside? You need to look at section 44 subsection 3B of the Family Law Act, which deals with cases where a divorce order has taken effect or a decree of nullity of marriage has been made and a financial agreement between the parties to that marriage has either been set aside under section 90K or found to be invalid under section 90KA. In those cases, the parties can apply for property settlement and maintenance proceedings within the period of 12 months after the later of the date on which the divorce order took effect, or the making of the decree of nullity, as the case may be, or the date on which the financial agreement was set aside or found to be invalid, or otherwise with leave of the court. Now, for de facto couples, the statutory requirement for applications relating to maintenance and property proceedings is outlined in section 44 subsection 5 of the Act, and it provides that a party to a de facto relationship may apply for orders for property settlement and or maintenance if the application is filed within 2 years of the end of the de facto relationship or 12 months after a financial agreement between the parties to that de facto relationship was set aside or found to be invalid, or otherwise with the consent of both parties. Now, given the limitation periods which are set out in the Act, it is critical that instructions are taken from all new clients about the date and the place of the divorce, if the parties are divorced, or the end of the de facto relationship, and advice given and promptly about limitation periods. If the parties were in a de facto relationship, it is important to tease out why the client says the relationship ended at a certain point in time. For example, is it when one of the parties moved out of the joint residence or the bedroom they shared? For those of you who are experienced family law practitioners, you would know that particularly in de facto matters, there is often a dispute between the parties as to whether a de facto relationship existed at all, or if it did, when did it start, when did it end? It is a lot easier if the parties were married to ascertain what the limitation period is, because you know precisely what the date of divorce is and when the limitation period runs out. We don't have that luxury in de facto proceedings. So very, very important to tease out why the client says that the relationship ended at a particular point in time. Now, the sections of the Act which deal with limitation periods for both married and de facto couples make it clear that the court may give leave to a party to apply outside of these timeframes if the court is satisfied, firstly, that hardship would be caused to a party to the marriage or a de facto relationship or a child of the relationship if leave were not granted. And in the case of proceedings in relation to maintenance, at the end of the period within which the proceedings could have been instituted without leave of the court, the circumstances of the applicant were such that the applicant would have been unable to support himself or herself without an income-tested allowance, pension, or benefit. The question then arises in these cases where the limitation period has expired, what constitutes hardship? Now, hardship is not defined in the Act, so it has been left to the court to determine. Very important to remember that an application for leave to apply out of time is an interlocutory application in nature. And what constitutes hardship has been considered by a vast number of authorities, and I refer to them in my paper. It is important that when you are reading some of the earlier cases that you be mindful of the fact that Section 44 of the Act has been amended over the years. So just be mindful of that, particularly when you are referring to some of the earlier cases. A very helpful summary of the various and relevant interpretations of hardship is found in the 2011 full court decision in Sharp. And I will take you through some of those earlier authorities. One of the first authorities is the case of McDonald, which is a 1977 decision. And in that case, the court held that Section 44(3) requires the applicant to establish in summary a prima facie case, which is in the circumstances substantial, that to deny the applicant the right to commence the substantive proceedings would cause hardship in the sense referred to in Section 44, subsection 4, and that there is an adequate reason and explanation for the delay in commencing the claim. Subsequent decisions of the full court have drawn a very clear distinction between the requirement to establish hardship in Section 44, subsection 4A, which includes a consideration of whether the applicant has a prima facie claim, and a consideration of the relevant factors to the exercise of the discretion to grant leave following that preliminary determination. So it is in effect a two-step process. The first step being whether the applicant can demonstrate hardship, and if they do, whether permission should be granted or leave granted for them to commence their application out of time. In terms of the meaning of the word hardship and how it has been interpreted in the decisions, the full court in the case of Whitford observed that, in their view, the meaning of hardship is akin to such concepts of hardness, severity, privation, that which is hard to bear out or a substantial detriment. The full court held that it is impossible to lay down in advance what particular facts may or may not amount to hardship in a particular case. In the case of Hall, the full court stated that the authorities have considered what is meant by the term hardship, and the term substantial detriment seems to be the generally accepted interpretation of the word. Now, although the mere loss of a prospective entitlement to pursue a substantive claim may not of itself constitute hardship, it is the consequences attending to the loss of the right with which the subsection is concerned. The full court in Whitford observed that hardship may be caused to an applicant if leave were not granted to institute the proceedings, although the applicant is not in necessitous circumstances. And whatever the financial situation of the applicant may be, his or her loss of a prospective entitlement to property, including money, or his or her inability to have the financial and property relations of the parties adjusted or resolved, may of itself constitute hardship. In some cases where a resolution of the property or financial relationships of the parties is desired, it might be that the applicant would receive no more or even less than what they already own at law or in equity, but nonetheless hardship might be caused to the applicant if leave were not granted to facilitate such resolution. The full court in Sharp held that it is apparent that an assessment of hardship requires the court to consider whether the applicant would suffer a substantial detriment as a consequence of the loss of the right to institute the proceedings, although that detriment in the circumstances of the particular matter may not be entirely related to financial considerations. And in their Honour's opinion, it is not possible nor desirable to define exclusively what will, in all the circumstances of a particular application, constitute hardship for the purposes of section 44, subsection 4A. However, in undertaking the exercise, the court should have regard to the nature of the jurisdiction exercised by the family court, and the power should be exercised liberally in order to avoid hardship, but nonetheless in a manner which would not render nugatory the requirement that proceedings should be instituted within a year from the date of the divorce. In undertaking an assessment of hardship, the court is required to consider whether the applicant has established a prima facie claim. And fundamental to a finding of hardship is a determination of the quality or character of the potential claim. Basically, in the context of whether on the applicant's material, he or she has a reasonable claim to be heard by the court. And that is the essence of the inquiry into whether hardship will be suffered by denying the applicant the right to litigate that claim. The court is quite clear in the authorities that it is not a determination about whether the claim will succeed, but rather whether there is a reasonable claim to be heard. In light of the authorities discussed by the full court in Sharp, on page 9 of my paper, I have summarised a list of the important points on the topic of leave and hardship. And in summary, they are, on an application for leave under section 44, subsection 4 or subsection 6, depending on whether you are dealing with a de facto matter or parties that were married, two broad questions arise. The first being whether the court is satisfied that hardship would be caused to the applicant or a child of the marriage if leave were not granted. If the court is not so satisfied, that is the end of the matter. So essentially, that finding of hardship is a preliminary or a threshold issue, essentially. So if the applicant does not satisfy the court, they would suffer hardship. The matter comes to an end. However, if the court is satisfied that the applicant or a child would suffer hardship, then we progress to the second question. And that question is whether, in the exercise of its discretion, the court should grant leave to institute proceedings out of time. So the discretion can only be exercised after a determination of hardship is made. And if hardship is established, the applicant must still then persuade the court that discretion should be exercised in their favour and they should be permitted to proceed out of time. His Honour Justice McHugh, in the High Court decision in Gallo and Dawson, held that the discretion to extend time is given for the sole purpose of enabling the court to do justice between the parties. And it is important to remember that Section 44, subsection 4 does not provide that leave must be granted if the court is satisfied that hardship would be caused. Rather, in determining whether or not to exercise the discretion, matters such as the length and the reason for the delay, prejudice to the respondent by reason of the delay, the strength on the merits of the applicant's case, and the degree of hardship which would be suffered need to be considered. And these matters are not necessarily the only ones. Now, there are a number of well-established guiding principles as to the exercise of discretion which stem from that High Court authority in Gallo and Dawson, and they have been distilled by the court as being as follows. The grant of extension of time, as I've mentioned earlier, is not automatic. The object is to ensure that rules which fix timeframes do not become instruments of injustice. They exist there for a reason. Since the discretion to extend the time is given for the sole purpose of enabling the court to do justice between the parties, the discretion can only be exercised upon proof that strict compliance with the rules will work an injustice on the applicant. When determining whether the rules will work an injustice, it is necessary to have regard to the history of the proceedings, the conduct of the parties, the nature of the litigation, and the consequences for the parties of the grant or refusal of the application for extension of time. And when considering an application for extension of time in which to file an appeal or an application, it is also necessary to consider the prospects of success of that appeal or application. In a leading High Court authority on limitation periods, being Brisbane South Regional Health Authority and Taylor, their honours Dawson, McHugh and Kirby were all of the view that limitation periods served legitimate purposes and ought prima facie be observed. They should only be breached when it could be proven that the interests of justice to all the parties require a departure from the statutory norm. And broad considerations of justice consider the grant of leave to bring proceedings out after the limitation period has expired. These considerations include an examination of the conduct of the applicant for leave and the reasonableness of the explanation for the delay. And much of what was said in this High Court authority has been regarded as of general application, although the case itself turned on specific provisions of the Limitation of Actions Act, Queensland. The Family Court has adopted similar considerations in deciding whether to grant leave, and in particular consideration of the length of the delay, the reasons for the delay, and prejudice to be occasioned by the respondent by reason of the delay, and the strength of the applicant's case and the degree of hardship which would be suffered unless leave were granted. It is therefore essential to approach the statutory discretion having regard to the context in which it appears and the purpose for which it is provided. It is right to observe that the objects of Section 44, subsection 3 and Section 81 of the Family Law Act demonstrate a policy that the financial relationship between the parties should, wherever possible, be brought to an end within a reasonable time. As stated in the decision in Mackenzie and Mackenzie, The court should exercise the power to grant leave under section 44, subsection 3 liberally, but only if it is satisfied that hardship would be caused to an applicant or a child of a marriage if he or she were barred from making a claim. As against this, the court cannot ignore the policy underlying section 44.3, which is that ordinarily proceedings should not be commenced within a year from the date of the divorce order. Now that we have a bit of background, I will take you through a number of decisions which are outlined on this slide, and a summary of all of the cases that are referred to on this slide can be found on pages, it commences on page 12 of the paper onwards. Now, the first one that we will go through is the case of Ordway and Ordway, which was an application where leave to proceed out of time was granted 23 years after the divorce was granted. So in this case, the wife sought an order under section 44.3 for leave to file property proceedings out of time 23 years after the divorce. The parties agreed that rather than having the matter determined in two parts, namely a threshold hearing on leave to apply out of time, and if successful, a subsequent section 79 hearing, that they would proceed on the basis that all issues would be heard and addressed at trial. Now, that is somewhat unusual, and ordinarily the course to be adopted is to have a threshold hearing first, and only if the applicant is successful would you then move on to the next stage, being the substantive proceedings. However, in this case, the parties decided to have all the issues determined at the same time. So in terms of the facts of the case, the wife and the children remained living in the former matrimonial home after the parties separated in 1983. The former matrimonial home was held in the husband's sole name. The husband continued to financially support the wife and the children post-separation. In 1987, the parties entered into a deed in respect of the wife's continued use and occupation of the former matrimonial home, motor vehicle and maintenance, which the husband was to continue to provide. The wife undertook some renovations on that property. The husband used the equity in the home as security for various other ventures. The wife also continued to work in the husband's business until after the proceedings were initiated in 2009. The court held that the parties, through their lack of action, continued to collaborate in what could be called a joint endeavour, whereby the husband had the use of the equity in this property after separation, whilst the wife had use of the property itself for the 26 years that followed before the wife took action to determine her share in the assets. The wife, in addition to being the primary caregiver for the children until they left home in 1999, continued to participate in the financial contributions to the acquisition, conservation and improvement of the property through her maintenance of this property, as well as the use of its equity in the husband's business dealings, equity that she was unable to access given the home was registered in the husband's sole name. The contribution of the husband can and should be balanced against that of the wife. He continued to work in the business, and the income he received assisted with servicing the loans on the properties that he had acquired. The court held that whilst there is an argument that contributions of each party to the other's assets were at best nominal, that argument ignores the central asset of this pool, which the wife used, maintained and preserved, and whose equity was used by the husband. Its role in allowing each party to acquire further assets, for without it, the wife would have been able, for example, to purchase another property, and that cannot be ignored. The court also held that there was some weight to the submission that the wife was kept in a financial cocoon, being unable to access her equity, which at the same time exposed her to the risk of the husband's business enterprise. At the conclusion of the hearing, the counsel for the husband conceded that the wife had, in all probability, satisfied the first step of the process, namely that she would suffer hardship if denied the ability to bring proceedings for property settlement. She would, in effect, be left with nominal assets and would be subject to hardship. The court took into account the fact that the wife had an informal financial arrangement with the husband, and she had feared disrupting the status quo by instituting proceedings. The court found that it was obvious when considering the parties' financial circumstances that there was a significant power imbalance between the parties. The wife was able to continue to reside in the house and rely on the husband for financial support. When she subsequently became employed within his business, the court accepted that she had concerns that if she pushed the issue too far, she would lose her job. The wife offered no explanation as to why she did not seek legal advice at the time of separation and why she did not seek legal advice until 2009. But the court accepted her understanding that she had an agreement with the husband and did not need to do so. The court also accepted that neither party was willing to disrupt the status quo and considered that the explanation for the delay was made out and that upon matters being clarified in 2009, the wife took appropriate steps and quite promptly. The second case that we will go through this afternoon is the case of Slocombe and Hedgewood. This was a case where leave was granted by the court 18 years after the divorce was granted. This case went on appeal, so the wife sought leave to commence property proceedings out of time, and the primary judge refused to grant leave to the wife to proceed out of time, and the wife appealed. You may recall at the start of the presentation that I mentioned that that applications for leave to proceed out of time are interlocutory applications, and leave is required to appeal a refusal to grant leave to institute proceedings out of time because they are interlocutory applications. Now, the background facts in this case were not controversial. The parties commenced living together and subsequently married in 1989. They separated some 5 years later in January 1994, and there were 3 children of the marriage. There were 4, 3, and just under 2 years of age at the time of separation. The parties were divorced in September 1995. Prior to the divorce, the wife consulted solicitors who in September 1994 wrote a letter to the husband in which they said that the assets at the date of separation consisted of the former matrimonial home, which had equity of about $15,000, furniture of about $10,000, and a car valued at $12,000. The wife took possession of the car when the parties separated and subsequently sold it and retained the proceeds. It was proposed in that letter from the wife's solicitors that the wife receive a number of items of furniture, which the wife asserts she did not ultimately receive, and proposed that in return for the car and the furniture, the wife would transfer to the husband her interest in the former matrimonial home. Ultimately, no agreement was reached between the parties and no orders were ever made by the court. At the time of the hearing, the only asset of significance was the former matrimonial home, which was valued in the vicinity of $350,000. And the mortgage was in joint names, which was about $43,000. So there was equity of about $300,000. The former matrimonial home was owned by the parties as joint tenants. At the time the parties separated, the wife left the home with the children, and the husband continued to have the benefit of living in the home, but he also paid the outgoings, reduced the mortgage, and made the improvements. The trial judge found that whilst the wife had established the requisite hardship and that she had a case that had reasonable prospects of success, the primary judge was not satisfied that the wife provided an adequate explanation for the 18-year delay. Further, the trial judge found that prejudice would be suffered by the husband if leave were granted out of time as a result of the significant contributions that he has made to the home over the past 18 years, and his reliance on the fact that no future property settlement claim would be brought against him. Therefore, the wife failed at first instance in her application. The finding of hardship on appeal was not challenged by the husband. The full court found that there was some reasonable explanation for the wife's delay, and also that the husband had been just as inactive as the wife in protecting his rights. In relation to the wife's knowledge of the time limitation, the wife explained that she had represented herself in the application for divorce. And despite a notation as to the limitation period on the divorce order document, the wife said that the first she knew of the time limit was in January 2013 when she consulted her current solicitors. The full court held that whilst it is essential for the proper operation of a system of justice for time limitations to be imposed, in appropriate cases, the interest of justice might overcome long delay and on occasions an inadequate explanation for the delay, which is only one of the factors to be considered in determining an application for leave pursuant to Section 44, subsection 3 of the Act. The full court referred to the well-known passage in Chisenko and Chisenko, which is a 1986 decision, where the court held the issues before His Honour were those which have been established in this court as long ago as 1977 in McDonald and McDonald. The applicant must establish three principal matters. First, a reasonable prima facie case for relief. Secondly, that denial of the wife's claim would cause her hardship. And thirdly, an adequate explanation for the delay. If those three elements are satisfied, the court should further, in determining whether to exercise its discretion to grant relief, consider the question of prejudice which the respondent would suffer by reason of the delay in bringing the application. In view of the lengthy time that had expired from the date of the divorce to the filing of the application, the full court held that the trial judge was correct to consider the prejudice to the husband. Now, although the delay in this case was significant, the full court nonetheless found that leave should be granted in the interest of justice, as the prospect of the parties' legal position remaining as it is appeared unjust. That either of them could make an application to a state court does not ameliorate the hardship to the wife. In such an application, a state court could not exercise discretion to apportion the proceeds of sale of the home to the wife by taking into account her contribution to the children during and including post-separation and other relevant matters. Therefore, the full court granted leave to the applicant to proceed out of time. As you can see from that case, really what the case turned on was that both the wife and the husband were inactive in taking steps to sever their financial relationship. And ultimately, if the court left the position as it is, the parties would find themselves still being joint owners of the property. And whilst they could make an application to a state court under Section 66G for those of us in New South Wales, or the equivalent legislation in other states, those applications do not necessarily take into account some of the factors that the family law system takes into account, and therefore the leave was granted. Now we'll have a look at a 2022 decision from Justice Austin in the case of Skelton and Lindom. This was a case where the parties were in a de facto relationship from late 2009 or early 2010, and they separated in 2006 on the de facto wife's case and in February 2004 on the de facto husband's case. In November 2018, the wife sought leave to apply for property settlement out of time. The primary judge considered that the de facto wife's contributions, both financially and non-financially, were minimal, and that she failed to prove on the balance of probabilities that the deprivation of the opportunity to bring a claim out of time would cause her hardship. The parties adduced evidence about the likely costs of the substantive proceedings. The de facto wife said the litigation would cost her $100,000, and the husband said it would cost him $110,000. The primary judge determined that the de facto wife failed to demonstrate that she will suffer hardship if precluded from bringing her substantive claim. The trial judge held that the court accepts that of the appellant's own evidence, her contribution, both financially and non-financially, would be regarded as so minimal that it would therefore be difficult on the balance of probabilities for her to establish any hardship. The respondent maintained that the costs of the appellant in pursuing her application, compared to the contributions made by her in the relationship, would exceed that which she is likely to receive on any property adjustment. The court accepts that submission. Accordingly, and noting the appellant's cost of pursuing any such entitlement would likely outweigh any reward, the court is of the view that the appellant's prima facie claim does not have a real probability of success. Now, two of the grounds of the appeal attack the above conclusions, contending they were not reasonably open. And in considering the contrasting positions of the parties, Justice Austin, sitting as the full court, outlined that the de facto wife was physically disabled and unemployed as a 60-year-old, and that the de facto husband was 58, self-employed, and owed significant assets. Given the de facto wife's relative penury, the deprivation of a claim was found by His Honour to occasion her hardship. Justice Austin also made important reference to the incorrect test that was used by the trial judge in considering the prospects of the substantive claim on the balance of probabilities and considering a reasonable probability of success of the claim. Justice Austin held that neither of those are the correct test. Rather, the correct test is sufficient likelihood of success, very different to the substantive claim having reasonable prospects on the balance of probabilities. Justice Austin further held that in this jurisdiction, one strand of authority speaks of the need for the applicant to demonstrate his or her claim has real probability of success, looking at some of the older cases such as the marriage of Whitford, and that the claim is reasonably arguable. However, that is not the current test. Also, the current test is not on the balance of probabilities. Justice Austin held that the trial judge's reference in the reasons for judgment to not being satisfied on the balance of probabilities, nor that the appellant's claim has a real probability of success, that those have the flavour of demanding more from the appellant than what she needed to give. She certainly did not have to prove it was more probable than not that her claim for property settlement relief would succeed if allowed to proceed. His Honour also looked at the facts of the case, namely that the parties lived in a de facto relationship for a number of years, during which time the appellant had made many noteworthy financial and non-financial contributions. The respondent did not deny that the appellant made contributions. However, he contended that her contributions paled compared to his. The appellant was 60 years of age and unemployed, and her physical disability, verified by medical evidence, hindered her capacity to obtain or perform any gainful employment. She was effectively destitute, and she had no assets and was reliant upon welfare payments to survive. By comparison, the respondent was 58 years of age. He was self-employed and owned assets which he admitted were worth more than $1 million. The appellant contended that his assets were worth much more than that, but this was an issue for substantive proceedings. His Honour found that despite a multitude of prospective factual disputes between the parties, the appellant had a reasonably arguable case on the evidence before the primary judge for a proportional share of the respondent property, given her contributions over the period of the de facto relationship and her comparatively superior future needs. And ultimately, the appellant was successful in receiving leave to proceed out of time. There was another full court case not long after Justice Austin's decision in Skelton and Lindop, and that's the decision in Hardwick and Hardwick number 2, in which the full court, which was comprised of Deputy Chief Justice McClellan and Justices Riethmuller and Strum, confirmed the appropriate test to be applied in these cases. Their honours held that, as recently noted by Justice Austin in Skelton and Lindop, there is differing authority as to the test to be applied in determining the prospects of success. Those tests range from the need to establish a prima facie claim to the need to establish a real probability of success, and we respectfully acknowledge and adopt the reasoning of Justice Austin that the appropriate test to apply is whether the applicant for relief had sufficient likelihood of success to prove hardship. So that remains the current test in these cases, sufficient likelihood of success. Now, this case was also quite helpful in that it summarises the approach in applications seeking an interlocutory order under Section 44(3). And the full court held that these applications are generally dealt with on the basis that the applicant's evidence is presumed to be correct, unless it is inherently unbelievable or contradictory. And it is important to appreciate that it is only in the event of leave being granted that the court at final hearing will make a determination in respect to the accuracy or otherwise of the parties' competing factual contentions. The second last case we'll look at this afternoon is the 2021 full court decision in Welland and Hawthorn. In this case is quite interesting because the court held that there was significant unexplained delay and leave to proceed out of time was not granted. So the primary judge dismissed the application pursuant to Section 44(6) of the Act, which was filed just 21 months after the expiration of the limitation period. The applicant appealed from that order, claiming that the primary judge misdirected herself when identifying the issues for determination and the relevant discretionary factors. There was considerable dispute between the parties as to the length of the de facto relationship and when it broke down, which had a bearing on just how late the application was filed. There was also an argument about the adequacy of the explanation for the delay and the extent of hardship the applicant will suffer if deprived of leave to bring the application for substantive relief out of time. The application for leave to proceed out of time was heard as a discrete issue, so as it was a threshold hearing, which, as I've mentioned earlier, is ordinarily how these applications are dealt with. The respondent came into the relationship with significantly higher assets than the applicant. And within months of cohabitation, the respondent purchased a property in his sole name, which became the family home. The respondent was arrested in 2010 and in 2011 sentenced to imprisonment for 9 years. The parties had 2 children together, which lived with the applicant from June 2010, but with the respondent upon his release from jail. The applicant first consulted solicitors in 2015, and she was advised of the limitation period. She did nothing to progress her claim at that time. She then engaged other solicitors between 2017 and 2019 for the purposes of bringing these proceedings. However, she did not file an application until November 2019, when she was already out of time. The trial judge was not satisfied with the applicant's explanation for delay, and her application for leave to proceed out of time was dismissed. Now, the full court affirmed that the application of section 44(6) of the Act entails satisfaction of its criteria by sequential steps. So step number 1, the applicant must demonstrate hardship, and only if that hurdle is surmounted, the applicant then must still persuade the court to exercise discretion in his or her favour to extend time. Supposing hardship is demonstrated, numerous factors can influence the exercise of the residual discretion, including length of the delay, the adequacy of the reasons for the delay, prejudice to the respondent, if the application for extension of time was granted. The full court cited the case of Arkand and Bowen, in which the full court referred to the Brisbane South Regional Health Authority and Taylor High Court case, which I've referred to earlier, where the High Court emphasised how a statutory provision conferring the discretion to extend a limitation period is the discretion to grant an extension. It is not a discretion to refuse an extension. The onus of persuading the favourable exercise of such discretion rests with the applicant. So it's not for the respondent to persuade the court that the discretion should not be exercised, rather the onus rests fairly and squarely on the applicant. In this case, the explanation for the delay was found to be inadequate, not least because the applicant admitted to receiving legal advice about the need to bring proceedings before the limitation period lapsed, and then she also received further advice after the limitation period had lapsed about the need to immediately bring the application for leave to proceed to avoid the accrual of any further delay. The applicant admitted ignoring that legal advice for a period of about 2 years between 2017 and 2019. On the facts of the case, the primary judge found that the applicant would indeed suffer some degree of financial hardship were she not granted an extension of time. However, the explanation that she offered for the delay in commencement of the proceedings was inadequate. When weighing those two competing considerations, the primary judge concluded that the applicant had failed to satisfy the court that the discretion to extend time should be exercised in her favour. Because those findings were open on the evidence, the exercise of discretion did not miscarry, and the applicant's appeal or the appellant's appeal was dismissed. So despite the court finding that she would suffer some hardship because the court was not satisfied as to the reason for the delay, she was not permitted to proceed out of time. Now, the final case we will look at is the case of Gazden and Simkin, which is a 2018 decision. I suggest that if you have any questions, that you start typing them into the Q&A box now, because I will probably finish going through this case in about 5 minutes, and then I will have some time to take questions and to deal with any comments. So if you've got any burning questions, feel free to start typing them into the Q&A. This case is quite interesting because it involved a significant benefit being received by the de facto wife already, and she was not permitted to proceed out of time. So the de facto wife filed an application for property settlement and spouse maintenance 7 years out of time. The trial judge concluded that she would suffer hardship if leave were not granted, and permitted her to proceed out of time. It was the de facto husband, so the respondent in the proceedings, who filed an application for leave to appeal those orders, and if leave is granted, for the orders to be set aside, contending that the trial judge failed to apply the correct legal test in determining the question of hardship. The husband did not pursue any challenges directed to any discretionary matters falling for consideration under section 44(6) if hardship is established. So really the appeal centred about, turned on the question of whether the correct test was applied on the issue of hardship and whether a finding of hardship should have been made. By way of background facts, the parties cohabited for 8 years. There were no children of the relationship, And at the commencement of the relationship, the de facto husband had assets worth some $4,750,000. The de facto wife entered the relationship with assets worth just $83,000. During the relationship, the parties lived in properties which were owned by the husband, to which the wife made no direct or indirect financial contribution to the acquisition, conservation, or improvement of those properties. During the relationship, the de facto husband also owned substantial commercial properties and held numerous corporate and trust interests, to none of which the wife made any direct or indirect financial contribution. The husband contributed about $100,000 to the de facto wife's superannuation account during the relationship. Post-separation, the husband paid the wife's rent for a period of time, and thereafter he also paid a $100,000 deposit towards the purchase of a property in the de facto wife's sole name. And the husband also paid interest on the mortgage repayments for that property. Approximately 4.5 years following separation, the wife moved into her new husband's property, so the wife had remarried, and she commenced receiving rental income from the property which the prior husband, the husband in these proceedings, purchased in her name. The undisputed affidavit evidence of the de facto husband was that he made post-separation payments and contributions to the applicant or for her benefit in the amount of $467,000. The de facto wife presently had assets of about $136,000. The wife's prospective legal costs in pursuing the claim were estimated to be between $100,000 and $150,000. The full court held that, having expressed her acceptance that it is fundamental to determining the question of hardship, to consider the quality or the character of the potential claim, nowhere in the reasons can it be seen that the trial judge undertook that consideration. After those references to authority in the reasons of the trial judge immediately moved to discuss the discretionary considerations of delay and prejudice to the husband. So the trial judge did not really address the question of hardship at all and moved immediately to the factors that go to the exercise of the discretion. In addressing the topic of hardship, Her Honour simply quoted paragraphs 23 to 25 of the wife's affidavit, which are directed only to her current income and expenses, and the fact that the de facto husband ceased paying the mortgage over her property. It would appear unavoidable to conclude that by this evidence, the trial judge was referring solely to the current financial circumstances of the de facto wife, as opposed to in the 3 paragraphs of her affidavit. However, that could not demonstrate hardship. An analysis of the potential claim of the de facto wife was necessary to determine whether or not hardship would be occasioned to her if she were not permitted leave to pursue that claim. Further, as the authorities to which reference has been made demonstrate, an essential element to consider is the prospective legal cost of pursuing the claim. The full court accepted the husband's submissions as to hardship. The husband saw that the full court re-exercise the discretion in relation to the de facto wife's application and dismiss it, rather than sending the matter back to a different trial judge for rehearing. That is ultimately what the full court ended up doing. And in refusing to grant the de facto wife's leave, the full court found that it was unable to see how her potential claim in property settlement proceedings could conceivably approach, let alone exceed, that which she holds, together with that which she has already received from the de facto husband. A striking feature of the case is that the de facto wife has received very significant benefits post-separation, including the product of the de facto husband's significant contribution to her superannuation during the relationship. So the de facto wife had received some $467,000 in post-separation benefits, including the superannuation contribution of $100,000. And therefore, the court held that the wife should not be or would not be likely to receive any further adjustment if the matter was to be, if she was allowed to proceed. She was unlikely to receive anything near, let alone more, than that which she has already received. And on the basis of the fact that the wife had received substantial benefit already, the court was not satisfied that she had established hardship, and her application was dismissed. So that is the end of the presentation. I see that we have some questions. Wayne asked whether the paper would be available for the participants. I did prepare a written paper, and it is my understanding that that will be made available to the participants.
Yeah, so I'll just advise Wayne. So it is available on your webinar platform at the moment. So towards the bottom, there is a button that is called Resources. And once you click on that, there is a tab called Documents, and there is the paper and the PowerPoint available there for you to download. But if you have any issues, you can always give us a call or email afterwards, and we can resend it to you if you aren't able to find it on the webinar platform at the moment. Perfect. Well, thank you so much for that. Just to our delegates, if you do want to get any last minute questions in, you can submit them via the Q&A button, and we'll have a check before we close the session out. But while we're waiting for the questions to come through, did you have any last minute things that you wanted to mention to the delegates just before we close out?
Yeah, look, just while we're waiting on questions, I guess just some takeaway remarks. If you are, when we are advising clients, it is so critical that we give them advice about limitation periods. And you will see one of the cases that I've referred to, one of the reasons why the applicant was not permitted to proceed out of time is because she had received legal advice and she was well aware of the limitation period. So very important for us to give that advice, keep very good file notes. In terms of other advice to clients, if they want to avoid finding themselves in a situation where an application for leave out of time is made, very, very important for clients to sever the financial relationship with their former spouse. As you can see in those cases where leave to proceed out of time has been granted 18 years and 23 years out of time, those were all cases where the parties have not severed the financial relationship between them. Rather, they have effectively kept their assets together. They're kept intermingling money. Assets remained in joint names. Those are the cases where the court will step in and will give leave to apply out of time. The court is not going to leave parties who may have been separated for a long amount of time, but still holding assets together. So clients need to be made aware that there is that risk that if they maintain financially tied to their spouse, that at some point down the track, an application will be made and the application will succeed. So the best thing they can do is get onto their financial settlement promptly and have it formalised properly. The first case that I talked about, which is the one where leave was granted to proceed 23 years out of time, the parties did enter into some kind of a deed document a couple of years after separation. However, that document was not a financial agreement. It was not consent orders. So really important for clients to be made aware that they need to formalise their any settlement which they might reach, formalise it via either consent orders or via a financial agreement, and make sure that they sever that financial relationship. Otherwise, that risk remains, and it can pop up to bite them 23 years or longer after separation and after they had remarried, accumulated other assets and the like. So I cannot stress that enough. I've acted for clients where they've come to me and they've said, oh, I've been served with this application by this person that I've divorced 10 years ago. However, they haven't done a property settlement and they still maintain some level of financial intermingling. So in those cases, yeah, the risk is high. So just be mindful of that. I've tried to give you a bit of variety in terms of cases, so that you can see sort of how the applications were, how you can try and successfully run an application for leave out of time, or if you are defending them as well, what are some of the factors which have swayed the court one way or another. So I hope that was helpful. I don't think we have any questions, so we might close the webinar here. Happy to answer any questions if you've got them, but otherwise I hope that was of use to you. And thank you all for your attendance.
Wonderful. Well, thank you so much, Tijana, for an excellent session today. And thank you everyone for participating in today's event. You will be redirected to our online exit survey shortly. We ask you to please take a moment to complete the survey as your feedback is very important to us. We thank you in advance for your feedback. Wish you a pleasant afternoon and hope to see you at another event by 10 the Education Network soon. Thanks again, everyone. Great. Thank you so much for that, Tijana. That went smoothly.
Excellent. Very good. I'm glad there were no technical issues or anything like that.
No, it all went smoothly and it all went fine. And I mean, we give the materials out to delegates and it's just sometimes they just can't find it still. So, but yeah, it's definitely distributed. And yeah, it was in the platform, but maybe they came in late.
Yeah, possibly. No, very good. Well, thank you for that.
Thank you so much. I'll be in touch via email, but thanks again for today. It was excellent.
Pleasure. Okay, have a nice afternoon. Bye.
You too. Bye.